welcome to the Torts Lightning Review.
Lightning Review!
This is a review, okay? It's for people who've already taken torts, law students studying for a torts final, law grads prepping for the bar, everyone else you're welcome to watch, but please don't use it to solve real-world legal problems. It's inadequate. I'm going to try to refresh your recollection about as much torts doctrine as I can in a very short amount of time. Here we go. Negligence Part 1, Overview and Existence of a Duty. Negligence has 5 elements. Negligence has 5 elements. 5 elements. Maybe some of you were taught that negligence has 4 elements or 3 elements. It doesn't matter. It's all the same law. Talking about elements is just a way of having a checklist. So 5 elements is just a more detailed checklist than 3 or 4 elements. It's just a way of breaking it down. So let's break it down, shall we? Duty of care owed to the plaintiff, breach of that duty, actual causation, also called factual causation or causation in fact, proximate causation, also called legal causation or scope of liability, and injury, also called damages.
Now, if you have all of them, then you have a prima facie case, and you got to move on to consider defenses. Affirmative defenses, contributory negligence, comparative negligence, assumption of risk, immunities, statutes of limitations.
So let's move on to existence of a duty of care. I've got 4 main points to cover. First, the big picture. The matter of whether a duty of care exists is in actuality a doctrinal tool for courts, i.e. judges, to do policymaking to control the bounds of where negligence law is going to spread its fingers through our society. Point 2, the general rule, which is that a duty is owed to all foreseeable plaintiffs. 3, the negative nature of the duty. It's a duty to refrain. In other words, there is no affirmative duty to act or to help someone unless an exception applies. 4th, a clarification about the general rule. Rescuers are considered foreseeable even if they really aren't. Now we'll move on to talk about those points in more detail. Let's take that first point first, because if we talk frankly about the nature of the issue of the existence of a duty of care, that helps the rest of the doctrine make sense. If you look at your average jury instructions on negligence, you'll find that the jury never gets to decide the issue of whether or not a duty exists. They don't get an instruction on that issue. And that's because if a negligence case has gotten to the jury, it's because either the judge has decided that a duty of care exists or the defendant has decided to not challenge that issue. In fact, in most cases, the existence of a duty of care is just a gimme. It's just very obvious. There's nothing interesting to talk about with regard to the existence of a duty of care. Car accidents, medical malpractice, duty is probably almost always a non-issue. Now, you can get interesting existence of a duty questions in more exotic cases. For instance, can producers of television shows have negligence liability for what the audience members do after seeing the show? Don't try this at home type cases. Can the producers of the TV show be on the hook for negligence liability for showing you how to do something dangerous? Now, those kinds of cases are going to grapple with the existence of a duty. It's going to be a live issue. And when the judge decides that, it's going to be a policy-making type of decision. But in most cases, existence of a duty is not very interesting. That's one of the most confusing things about it for students, is that it's just really a non-issue in almost all cases. But we need a duty of care if we're going to have something to breach. That's the second element, and there usually is a big argument over whether or not the defendant breached their duty of care. Second big point about existence of a duty of care is the general rule. The general rule is a duty is owed to all foreseeable plaintiffs. If I'm driving my car on the road, all the other drivers and passengers around me, all the people on the sidewalk,
in the buildings near the road, all the people who own property near the road, or owners of cars or owners of things inside cars traveling nearly on the road.
They're all foreseeable plaintiffs because it's foreseeable I could injure them if I don't drive carefully. Palsgraf versus Long Island Railroad. You remember that case? I think you do. You remember that case? I think you do. I know that's not the clearest case in the world, but what is clear is that a defendant owes a duty to a foreseeable plaintiff. One way of boiling down the case is that Cardozo's majority opinion, which is often labeled the majority view in American tort law, is that a defendant owes a duty to all foreseeable plaintiffs, and beyond that, they don't owe a duty.
Then the Andrews dissent is essentially you owe a duty to them plus others, like everyone who is proximately caused injury by your negligence.
That's one way of boiling it down. Okay, whatever. At least what's clear from that is that a defendant owes a duty to a foreseeable plaintiff. And if the plaintiff's not foreseeable, then maybe the defendant owes a duty if it's a courtroom in which the winds of Judge Andrews are blowing around and broadening that duty a little bit. Another way of boiling down Palsgraf versus Long Island Railroad is to say Cardozo didn't want that case to go to a jury. He wanted to make a policymaking type decision to keep Palsgraf and people in her position from being able to sue the railroads. That's also true, and that goes back to the first point about the existence of a duty being a tool for the courts, i.e. judges, to decide that certain cases are not going to be entertained in court, not going to be allowed to reach a jury, aren't going to be things for which we allow recovery. Third big point about existence of a duty is the fact that the duty is a negative one. The duty is a negative one. It's a duty to refrain from conduct that could be injurious to other people. There's no duty to affirmatively go and assist people to go help them. That's the general rule, no affirmative duty. But there are exceptions. 4 categories of exceptions I'm going to talk about, and the exceptions are important. First exception, assumption of duty by acting. Second exception, peril created by the defendant's negligence. Third exception, control of third persons where the defendant has the ability and authority to do so and knows that the third person is likely to do harm. And fourth exception, special relationships. So let's talk about that first exception to the general no affirmative duty rule, which is assumption of duty by acting. So in general, you don't have an affirmative duty to come and help someone, but if you start to help them, you assume a duty. So for example, let's say that you come across the scene of a car wreck and you stop to help. You didn't have to stop and help, but once you did stop to help, now you have a duty to be non-negligent, to act reasonably in what you do when you're there. So once you've assumed a duty, you have to do it in a way that is in accordance with reasonable care. And if you don't, you can be on the hook for negligence liability, including leaving then without calling for help or rendering any aid. That could be something that the reasonable person wouldn't do. Second exception, peril created by the defendant's negligence. If your negligence causes a car crash, then you have an affirmative duty to come to the aid of people who've been put in a risky situation because of your negligence. Say your negligence has caused a car crash, the plaintiff in one of the cars is bleeding and in danger of having a permanent injury if they don't receive prompt medical attention, and let's say you have a cell phone and you don't dial 911, and let's stipulate that reasonable prudence would be dialing 911 to get that person help in that situation. If you don't do that, then you've breached your duty. So your negligence created the peril, then you have an affirmative duty to come to the aid of people to prevent further harm. Third exception to the general no affirmative duty rule is control of third persons. Sometimes, not usually, but if the defendant has the ability and authority to control the third person and knows that the third person is likely to do harm, then they have an affirmative duty to control that third person. For instance, you're the parent of a little fire starter, a child that loves to go around starting fires, and you're in a restaurant with lit candles, and you know that your kid is likely to go and set something on fire with one of the candles. You have the ability to control them, you have the authority to do that, and you know they're likely to do harm. You have an affirmative duty to step in and stop your little fire starter. Adorable fire starter. Nothing against your kid, very adorable. But you have a duty to step in and control them to prevent them from doing harm. But to be clear, generally there's no duty to control the behavior of third persons. Just if you have the ability and authority and you know that they're likely to do harm. Fourth exception to the general no affirmative duty rule is special relationships. So for instance, parent to child, daycare provider to child, lifeguard to pool patron. If you've been hired as a lifeguard, you have an affirmative duty to swimmers. You've been hired as a lifeguard, you got to jump in the pool if someone seems to be drowning. But if you're a pool patron who happens to have lifeguard certification and it's easy for you to save someone from drowning, but you don't feel like it because you're reading a book and you're involved in your book, then you don't have an affirmative duty. And just sitting there, not putting your book down to help someone who's about to drown will not create negligence liability for you. It's tough, but that's the no affirmative duty rule. Other categories of special relationship: common carriers to passengers. So airlines, railroads, city bus service, where the general public can walk up and buy a ticket on that conveyance. You're a passenger then on a common carrier, and they have a duty, an affirmative duty, to render assistance to you. Shopkeepers and innkeepers to their patrons, they have an affirmative duty. You're at a hotel, you're walking through the lobby, suddenly you start having a heart attack, you fall down on the floor, they have an affirmative duty to help you. They should call 911. They can't say, oh, we don't want to be involved. You are a patron in an inn or a store, they have an affirmative duty to come to your assistance. That was the no affirmative duty rule and exceptions to that. Now let's go back. Our big 4 points were: first, some context about the big picture and the policymaking role of the existence of a duty of care and how it can keep things from getting to a jury. The second big point was the general rule that a duty is owed to all foreseeable plaintiffs. The third big point was the negative nature of that duty, or the no affirmative duty rule, which is that while you have a duty to refrain from hazardous conduct, there's no duty to come to someone's assistance unless a special exception applies, and we talked about 4 exceptions there. Now we come to the fourth big point about the existence of a duty of care, which is about rescuers. It's a clarification or a specific instance of the general rule that courts have come across many times, and they just have a pat answer to it, which is that rescuers are always considered foreseeable plaintiffs, even if they really aren't. The slogan here is "Danger invites rescue." That pretty much encapsulates it. So if you put someone else in harm's way and a rescuer gets injured trying to help them, you're on the hook for the rescuer's injuries. For example, I drive my car like a doofus, I lose control, I fly off the road down an embankment. And someone sees this and then they stop their car and they come down the embankment to help me. I could put myself in danger or someone else in danger, it doesn't matter. And they come down and in the dark, it's at night, and they try to reach me down that embankment and they break their ankle. You put yourself in trouble, danger invites rescue. You can't be off the hook by saying, well, it wasn't foreseeable that someone would come in to rescue. You can't say, well, that's on you. You came to help me. You didn't have to do that. That's on you. You get injured, break your ankle doing that. It doesn't work like that. Rescuers are considered foreseeable plaintiffs, even if they really aren't. That's the overview and the existence of a duty of care. Now, another question is, now that we know a duty of care exists, what is the standard of care? What is the measure by which we determine whether or not someone's breached their duty of care? That I'm going to cover under the next element, breach of duty of care.